Ready? All right, this next panel is on the topic of BDSM and the criminal law. From left to right, we have Breana Vandebeek, who's a partner at Gorham Vandebeek, practices in both Toronto and St. John, New Brunswick, appears frequently in the Ontario Court of Appeal, and is currently completing her SJD degree. Next, we have Janani Shanmuganathan, who runs her own law firm where she practices criminal law and professional discipline, often appears in the Court of Appeal and the Supreme Court of Canada. And then finally, we have Judge Christine Mainville, who sits in Toronto. Christine and I, as some of you know, have been married for 13 years. So imagine my surprise to learn recently that she considers this a special area of expertise. I'll turn it over to our panel.
Start by saying this. There have been a lot of great graphics on the screens this morning, especially. There will not be any for this panel. This is, I feel like there's been a lot of hype. This is no 50 Shades of Grey. It may be 50 Shades of Legal Analysis because I warn you, the law is quite muddy in this area. But it is of interest, of current interest. It presents issues that we're encountering, I think, with increasing frequency in the criminal courts, in part given the prevalence, in particular among youth, of BDSM type activities. I refer you to our paper, which is in the materials, that includes reference to a recent New York Times essay that was entitled "The Troubling Trend in Teenage Sex." It will make you want to speak to your kids. It details the rapid rise of rough sex among college students, particularly sexual strangulation or choking. Get this statistic, which surprised me, nearly 2/3 of women from a US campus representative survey, so college-age students, said that a partner had choked them during sex, and 2/3, which is, to me, quite incredible. And we also see an increase amongst adults across the US. I'm assuming Canada would see similar statistics. Of course, this is, to my mind, fraught with risks, not only when it goes too far, but when the boundaries of consent are unclear, or where the activity charts into territories where consent might be vitiated. It's especially risky in a context where, according to this same survey, many young women experienced choking on an initial sexual encounter with a partner, and most reported that their partners never or only sometimes asked before grabbing their necks. And I think, as we all know in this room, this has all the ingredients needed to produce a criminal complaint. So that's where we are. And as it stands, the boundaries surrounding consent in this area are not entirely clear. And note even that we see some discrepancy in how this is charged. Sometimes it's a simple assault. I've had a case recently, it was a simple assault. Even though it was in the context of sexual activity, of course, it can be charged, of course, as sexual assault. We see assault or sexual assault caused bodily harm. And then there's a newer offense of assault by choking in section 267 sub C. And sometimes that can make a real difference. So pay attention to how it's charged. I think even just for 276 purposes, although keep in mind the recent case of AM that Associate Chief Justice Fairburn referred to earlier in respect of, how that might apply in respect of an enumerated offense, which may be broader than just the enumerated offenses. So there's lots of room for new case law on this, given that the boundaries are very much unclear as yet. We did early on have the case of JA in the Supreme Court from 2011 regarding advanced consent, where the court considered whether a person can provide consent to sexual activity in advance to take place while unconscious. The accused and the complainant in that case had agreed that he would choke her, and she understood that she might lose consciousness, having experienced that before. Based on the evidence, she was out for under 3 minutes, and the accused engaged in sexual activity with her while she was unconscious, including inserting a dildo into her anus. She later complained to the police that that activity that took place while she was unconscious was not consensual. The question was whether she could consent in any event, so whether the Crown had to prove the absence of subjective consent beyond a reasonable doubt. The majority held that a person cannot provide advance consent and that an individual must be conscious throughout the sexual activity to provide the requisite consent. That analysis is informed by principles that we know, the fact that consent involves the complainant's state of mind at the relevant time. It relates to her conscious agreement to take part in every physical sexual act in the encounter, and the fact that the complainant may revoke or limit her consent at any time. And of course, a person cannot do that while unconscious. That drove the reasoning in JA, and that is one clear limit on where the line is drawn in what might transpire in a BDSM context. JA, however, did not address whether one can consent to unconsciousness at all, or whether loss of consciousness constitutes bodily harm such that consent may be vitiated. So we will address that issue, and more broadly, vitiation of consent where bodily harm is occasioned, the nature of the bodily harm that may vitiate consent, and the intent required vis-a-vis the bodily harm, so whether subjective or objective consent, intent is required. But we'll start with pretrial issues that may present themselves with, some frequency in these cases. In particular, adducing evidence of prior sexual history relating to having engaged in this type of conduct in the past. So 276 applications in this context. And note how when I spoke about JA, I mentioned that in that case there was evidence led that the complainant had previously lost consciousness while engaging in choking. It's not clear, at least from the Supreme Court reasons, how that was led, but it may well be that the Crown could wish to rely on such evidence to show subjective intent vis-a-vis loss of consciousness, and that would require its own Crown C. Boyer application. So in any event, to talk to us more about the admissibility of such evidence is Breana.
So with respect to 276 and BDSM cases in particular, there's very little binding authority on this, so no one should feel like their hands are tied in any way. But so I propose to talk about two cases that deal with BDSM issues in particular and 276 arguments. And so the first case is a case called Marsden. It's a 2022 case of the Superior Court of Justice. And these are all cited in the paper that was provided. Marsden involved a long-term relationship where the accused was charged with choking and anal rape. The accused and the complainant were in an ongoing relationship that involved a rape play or non-consensual acting of sex. And so as part of their rape play, the words no or screaming, which would usually indicate the revocation of consent, was actually considered part of their consensual sexual activity. And so part of what was filed in the 276 application was information about how they communicated the lack of consent. So they had a code word called red, or there was different ways where the complainant could tap out. And there was also a series of text messages between the complainant and the accused during the course of their ongoing relationship, explaining that they intended, what sexual acts they intended to engage in. And so the issue was whether or not this correspondence and their prior history in terms of that, the context of their rape play, whether or not that could be admissible under the 276 application, and it was successfully admitted in that case. The court said that this was sort of an exceptional situation where it would be impossible for the accused to raise a full answer in defense if this evidence wasn't admitted. So in that case, it was admitted. Now, unfortunately, in the case that I litigated at the Court of Appeal, McMillan from earlier this year, that involved a a BDSM 276 application where it was a first-time sexual encounter between the accused and the complainant. So some of you may have heard about that case where bartenders at the College Street Bar in Toronto were charged with sexual assault for an ongoing sexual encounter that was captured on videotape at the bar. The complainant testified that she didn't really remember what happened and she wouldn't engage in this type of activity. The two accused testified that it was part of an ongoing BDSM role play. And so there was two types of 276 evidence that sought at trial and then on appeal to be admitted. One was evidence of the complainant's statements and conducts earlier on in the same evening. So that was statements that she was making about her interest in this type of behavior, and as well as her interest in attending a BDSM type sex club with one of the two accused prior to, just hours prior to the sexual activity that took place on the videotape. The other type of 276 materials that sought to be introduced was text and Instagram photos or social media posting made by the complainant and publicly shared with the world that demonstrated that she had a prior interest in engaging in this type of sub-dom role play. And so both at trial and at the Court of Appeal, they say, nope, not admissible, can't go in at all. And there's sort of 2 points that the Court of Appeal relies on in saying it's not admissible. The first is that they take a very narrow view about the time frame of when the prior sexual acts can relate to. And so they talk about how, sort of citing JA and Barton number 1, they talk about how the only relevant period in question when you're ascertaining in consent is the exact time that the touching occurred. And so this obviously presents, in my view, sort of 2 practical problems, one practical and one legal. The one problem is that as a practical implication of this, it became very difficult for the accused, and you could see this in the appeal record, for them to present their case, because both during the cross-examination of the complainant and during their own testimony, they weren't able to recount the events that happened in that evening at the bar. And so it ended up with a record where there was very weird responses from the accused, like, sorry, I'm not going to answer that question because I don't want to offend Your Honor's ruling, which obviously plays out terribly in front of a jury. And so it's a situation where people want to, if you get rulings like that, we need to think about creative solutions in terms of other remedial charter applications or things that can be brought to salvage a situation like that. The legal implication that I think is sort of problem or the strange situation we have now is that the 2024 case of the Court of Appeal in Reimer seems to somewhat go against this idea of the prior sexual, sort of that the time frame is limited to the exact time of the sexual touching in terms of the admissibility of prior communications. And so in Reimer, Justice Pachaco admitted text messages of a 276 nature. It wasn't of BDSM, but it was 276 type text messaging, where the complainant had agreed to sexual activity earlier on in the night as relevant to the issue of whether or not she consented at the time. And so that's obviously seems in stark contrast with the decision in McMillan. Reimer is presently, the Crown has sought leave to the Supreme Court of Canada, so it's a case to look out for in terms of where we go from there. The second issue that comes out of the McMillan case is that the court said that what the trial lawyer was doing and the appellate counsel was trying to sort of carve out an exception for unconventional sex to allow sort of 276 materials to come in. And so part of the argument, both at trial and appeal, was that lay people or just people in general may not understand the prevalence of this type of activity in the context of a first-time interaction. And that was why the 276 materials should have been admitted. the Court of Appeal obviously says no, and that the jury for themselves can use their common sense and human experience to decide whether or not this type of BDSM behavior is possible or consensual in a first-time encounter. But, what I would say is that, even a very cursory view of the existing case law shows that judges who are even trained in trying to check their biases and have an open mind in terms of the case law struggle with even understanding sort of consensual sexual behaviors and what's common and what's not, and what might not happen in a consensual encounter. We can just look at the cases of JL from 2018 in the Court of Appeal. We have a judge saying that, a young woman wouldn't go outside in the wet dirt and have sex when she's wearing a dress. There was CPIC, again, in 2019 at the Court of Appeal, where the trial judge said that it would be completely implausible and nonsensical that a woman who was her first time at a strip club would touch a man's penis. And then my favorite one, because this was my case that I was successful on, was where the trial judge said that the complainant would not want to have her clitoris rubbed while she's on her period in a car unless she was some sort of fetish freak. And that's That's a 2024 decision of the Court of Appeal. So judges are struggling with this issue. So the idea that, juries or even judges would think that, the BDSM type first-time interactions is just a common sense thing to consider, I would say is probably not correct. And I think that's where I'll hand it over to Christine and Janani to talk about potential expert evidence on that issue.
Yes, so what do you do, because Breana raises a fair point. You're concerned a judge or a jury of a certain age, perhaps born in the 80s or earlier, won't believe that, this lovely young woman would have consented to engaging in such activity at all, and much less on a first encounter with someone she barely knew. Can you do anything to bring to the court's attention the kind of statistics I've mentioned, and that are set out in that New York Times article, for one, regarding the prevalence of such encounters? Should the court or the jury be made aware that, according to one of these studies, a quarter of young women that were surveyed in the study said it had happened with partners with whom they engaged in sexual relations on the day they met, because judges might indeed fall into error in thinking that it's a common sense inference that they don't. But what if you don't have prior sexual history evidence, which is itself sometimes difficult to adduce? Can this sort of social context evidence feature in a trial? Janani, if you have thoughts on that before I chime in.
Yeah, I think that I don't think it's been litigated yet, but I certainly see that it is an area of litigation that's ripe for us to pursue. And it's not just trial judges who engage in this kind of thinking or aren't sure sort of what is appropriate, what is not appropriate, what would people consent to, what would not. Just recently, in Jacob Horgaard's second case that was defended by Megan Savard and Callie Ho, the accused testified that the complainant had urinated on him, and the Crown, in cross-examination, said, that's much more in keeping with a coercive sexual encounter. And to Megan's credit, she stood up and said, I object on behalf of every person in society who has any kind of fringe sexual preference. So I think this kind of evidence is useful not to sort of cure just the stereotypes that trial judges may have, but also to dilute any form of cross-examination that the Crown may want to pursue.
Right. So there are certainly obstacles to adducing such evidence that I think you want to have at the forefront if you're raising this. It's, the argument that whether others consent to it doesn't mean this particular complainant was more likely to have consented. So the Crown, I'm sure, would stand up and object to the relevance of it to what happened here in this case, saying it distracts from the issues, it's more prejudicial than probative. There might be an argument to make that it's not about trying to make it more likely that this complainant consented based on how other women may act, but to neutralize any flawed common sense inference, or assumption, rather, that a young person or someone in these circumstances would not have consented to such activity. The difficulty, though, again, then, that you'll encounter, I think, is that it's a line of reasoning that judges are generally obligated to avoid in any event, right? So, like in the case of JL that Breana mentioned, where the trial judge was overturned for thinking that's not, I can't accept that this complainant would have acted in this way. So you'll be met by that objection. We're not supposed to reason in that way in any event. A jury can be instructed that they cannot reason in that way in any event. But we do see the risk of these common sense assumptions, so to speak, as they're termed in the appellate courts, that they happen. And so you kind of want to try to prevent that from happening you want to prevent the error from happening in the first place, if that's possible. So, shall we move on to the next topic? So, we'll turn now to vitiating consent. So, in what circumstances can one consent to pain or injury in a sexual context? In other words, how does the law apply to encounters where bodily harm is caused? Given the principles from Jobidon, which is a seminal case from 1991 from the Supreme Court, which sets out limits on the types of assault to which a person can lawfully consent. That case related to a consensual fist fight, and in that context, the court found that a person cannot consent to bodily harm as it is defined in the code, if that harm is both intended and caused. And that was clarified subsequently in the case of Pace, P-A-I-C-E, from the Supreme Court in 2005. But this was very much a policy-driven analysis, dependent on the context and the social value attached to the activity that was an issue. The court indeed made clear that the same principle might not apply in other social contexts. And in Jobidon, the policy that vitiated consent in the fistfight context was founded in the common law. And so what about the sexual context? And what of BDSM-type activities? In the sexual assault context, the criminal code sets out situations that will vitiate subjective consent. See sections 265 and 273.1, sub 2. This includes situations where the complainant is unconscious. So the criminal code specifically addresses the fact that someone cannot consent when they're unconscious. That's at 273.1 sub 2. But causing consensual bodily harm during sexual activity is not expressly prohibited in the code. But those statutorily enumerated factors are not exhaustive, and some courts have relied on the common law to designate additional situations where consent will be deemed not valid in the sexual assault context. To determine then whether the common law imposes any limits on consent in this context, the analysis is necessarily informed by the different social context and society's evolving acceptance of some forms of BDSM. And the Court of Appeal indeed has acknowledged that in the leading case of Zhao, Z-H-A-O, from the Court of Appeal in 2013, which recognized the social utility of intimate sexual relationships as compared to the social uselessness of consensual bar fights. Some here might disagree on the uselessness of, but still that's the view of the appellate courts, and the courts nevertheless have imposed, despite acknowledging that there is more value to sexual freedom and allowing people to do as they please to some larger extent in an intimate context than a bar fight. Still, the courts have begun imposing some limits, some common law limits on consent in this context. So Janani will tell us about that.
So the area of BDSM poses some interesting questions for criminal law because pain is an integral component, whether it's whipping, bondage, paddles, whatever your sexual flavor, there's some kind of pain and physical harm involved. But where have the boundaries been drawn? What type of bodily harm cannot be consented to? And this is a very confusing area of law, and I don't say this to shame anyone, unless, of course, you're into that kind of thing. Now, in Ontario, the definition of bodily harm in sexual context is no different from the definition found in Section 2 of the Code, which applies in non-sexual contexts. Bodily harm means any hurt or injury to a person that interferes with the health or comfort of the person and that is more than merely transient or trifling in nature. The first key case in Ontario to consider the issue of bodily harm in the sexual context is a Court of Appeals decision in Welsh from 1995. The bodily harm at issue in that case was what the court termed sadistic sexual activity, which included bondage and the intentional infliction of injury to the body of the complainant. Welsh said you can't consent to a charge of sexual assault causing bodily harm in circumstances involving sadomasochism and the deliberate infliction of pain. In the years since Welsh, Ontario courts continue to rely on the same definition of bodily harm, but there are lingering questions on whether certain sexual acts constitute bodily harm and the evidence required to support such a finding. And the sexual act of choking is one such example. So on one hand, we have the case of Kelly from 2024, where the complainant testified that while they were having consensual sex, the accused choked her to the point of unconsciousness. The trial judge adopted the code definition of bodily harm and found that it was transient in the sense that it didn't last very long, but that it wasn't merely trifling because the air or blood flow to the complainant's brain was cut off to the point where she fell over and the extent of a loss of consciousness was such that the complainant had no sense of how long she'd passed out for. This wasn't merely trifling, even though no expert evidence was called. By contrast, a different conclusion was reached by a trial judge in the case of Bryce Brown, which is also a 2024 case. During that consensual sexual encounter, the accused had also choked the complainant until she lost consciousness. But unlike Kelly, the trial judge in Bryce Brown found that on the evidence before her, she couldn't conclude that the choking resulted in bodily harm. No expert evidence was called on the point of the long-lasting effects of a person's unconsciousness, of a person losing consciousness, and the complainant's evidence was brief and didn't touch on any details of the injuries or long-lasting harm that was caused. So where the Crown doesn't call any expert evidence, the defense may have an argument that they haven't established that the injury amounts to bodily harm. Alberta, however, has taken a bit of a different approach. In Barton No. 2, the Alberta Court of Appeal chose to create a separate definition of bodily harm, which the court terms significant bodily harm. And the threshold at which vitiation of consent to sexual activity will operate is, quote, any hurt or injury that interferes in a substantial way with the integrity, health, or well-being of a person, which does not include injuries such as a cut or bruise that would normally heal within a few days. So the Alberta Court of Appeal has gone a different route. They've created a definition of bodily harm in the context of sexual encounters that builds in this allowance for injuries, because the court seems to recognize that there's some degree of hurt or harm that naturally flows from BDSM activities, and that some segment of the population enjoys this type of activity. In the court's words, it is open to adults to seek sexual experiences without judgment, and that where choices are safe, sane, and genuinely consensual, mingling sensations of pain and pleasure does not give rise to policy concerns. Ooh la la, Alberta. So Alberta and Ontario's approach to the definition of bodily harm in the sexual context is different, and perhaps Defense Counsel may want to push the envelope a bit more in Ontario because the Supreme Court has yet to weigh in on the issue.
Now, lest you think Alberta's more progressive on this than Ontario, I think it should be made clear that, and Breana will speak to this in a moment, while in Alberta they sort of enhanced the threshold for the type of bodily harm that might vitiate consent, they adopted the position that sorry, I'm not stealing your thunder. Sorry, I just want to get to another point. The intent is the intent requirement is lesser in terms vis-a-vis the bodily harm, versus in Ontario, the law as it was applied in the two cases Janani mentioned, which are Ontario Court of Justice cases, they were bound by ZAO in the Court of Appeal for Ontario, where that sort of lesser threshold for bodily harm was adopted, but a higher intent than in Alberta. So it leads to, maybe similar results at the end of the day, although not quite. But I did want to mention that the bodily harm issue in ZAO, which is the leading case in Ontario, if you have a case like this, was not directly addressed, because in that case the charge was sexual assault causing bodily harm, and Chief Justice Tulloch, who wrote that decision, basically just accepted that the definition of bodily harm was the same as the one that applied to the offense that was before the court. So the focus of that decision was really the intent issue. And so I think it is open to argue something different still, even though ZAO binds us, or binds the lower courts here for now. I think there's still a lot of room to negotiate that. But Breana, what about the intent then? What form of intent is required to render the person criminally blameworthy in this context?
Right. So as Christine kind of alluded to, in terms of the intent, the case law differs between Ontario and Alberta now after Barton 2. So in Ontario, ZAO is the leading case on intent, and there is you have a subjective intention. The accused has to have a subjective intention to cause the bodily harm in order for consent to be vitiated. And what comes out of both ZAO and Barton 2 is that the decision on the level of intention, and I guess also from Jobadon, is that these courts are really doing sort of a policy analysis, or the decisions are really policy-based in terms of the framing of what intention is involved. So Justice Tulloch in ZAO finds that it must be a subjective intention to vitiate bodily harm, and in making that finding, he overruled or at least questioned the prior jurisprudence in Welsh, which dealt specifically with a BDSM case. And the reasoning behind that was that he made an argument that the social utility of sexual activities was greater than that of consensual fistfights. So that kept with the subjective requirement. In Barton 2, however, Alberta takes a different view sort of on policy grounds, and while significant bodily harm has to be required, so what Janani talked about, only objective foreseeability is required on the part of the accused. So there's potentially a higher threshold for the bodily harm, but a lesser threshold on the intention. And in reaching that conclusion, again, the courts rely on policy considerations. The court noted that the defense of sexual assaults causing bodily harm was overwhelmingly brought by men in situations where the women were the complainants. And they rely on other policy arguments, such as the inherent gendered power imbalance in rough sex situations, as well as the disproportionate effect of sexual violence on minority groups. So even though there's a lesser threshold for the intention, so it's kind of flipping between the two. And I guess where this leaves everybody is that there's a lot of different policy considerations or debate around what the intention should be for vitiating consent, and questions about public policy arguments about whether the court should even be engaging in this type of analysis, or whether this is something that should be left for Parliament to decide. Balancing ideas between paternalism and individual autonomy, and then these questions about social utility of sex as opposed to social utility of fistfights are all sort of what's framing the discussion or the court's decision on these things. So I'll leave it at that.
Thanks. And I think the oddity of Barton number 2 and where it leaves us, or it leaves Albertans, is that by endorsing this objective standard of liability, it's easier to be convicted of engaging in consensual sexual activity that results in bodily harm than it is a fist fight with the same consequences, even though the Court of Appeals have accepted that we attach more social utility to an acceptance of BDSM-type activity than we do to bar brawls. So it is of an odd outcome in that respect, but and the other point that's pointed out by Peter Sankoff, who I think is here, in his leave application, he was appellate counsel on Barton number 2, it's that it also created the only type of sexual assault punishable on an objective standard of liability, where guilt flows from causing objectively foreseeable bodily harm notwithstanding consent. So the Supreme Court did deny leave on that. It'll be left to another day. I don't think they wanted to deal with the Barton facts twice. But to me, I think the intent is really the central part of it, because, based on the principles that the Supreme Court did address in JA, in the advanced consent case, in a context where we're talking about loss of consciousness, it's, how can one consent to unconsciousness when one cannot or has no ability to control how transient or trifling it might be? And I stand to be corrected by any BDSM experts in the room, but it seems to me that how long one might be passed out for is not something you can really plan with much precision. So if the intention is not loss of consciousness, then that's fine, but there's a risk that it can happen, then fine, you don't have the subjective intent, at least in Ontario, that is required. But where that is the intention, loss of consciousness, then how does that mesh with the principles in JA that one needs to be able to withdraw consent at any time? You can't do that while you're unconscious. You can't say, I want the loss of consciousness to stop now. And you can't control how long that loss of consciousness will be for. So I think if you read JA carefully, just based on what the Supreme Court decided there, and many people can disagree on what they decided in that case, but just based on that, I struggle to see how loss of consciousness in and of itself would not meet the threshold of bodily harm that the Supreme Court would say would vitiate consent, provided it is intended, right? Because even in Kelly, the decision Janani referenced that I wrote, so it was really the complaint became lost consciousness 3 to 5 times. And so the first time in the decision, the finding is, I don't know that it was, I couldn't find that it was intended, but once it happened once, it was clear when it happened 5 times that was the intention, or at least it was a very real possibility that it was going to happen again, right? So it was all about the intent.
I feel like the ideal world would be Alberta's definition of bodily harm coupled with Ontario's definition of inclusion of subjective intention, then mesh it all together. So for anyone who's got any BDSM cases, I think that's the formula that we should try to advocate for.
But definitely, as we've, I think, tried to emphasize, the law is open on this for now, for the most part, and so it's far from settled. So go and litigate, and a recommended read that's in our paper is by Colton Fehr, F-E-H-R. It's in the Manitoba Large Journal, and it talks about this point that was referenced about how the Supreme Court in particular, but really none of the courts, not in Zao, and I don't think in Barton number 2, have really contended with the policy arguments that, like those that were contended with in Jobidon, like, the pros and the cons of this type of activity and where that should lead us in terms of common law limits on vitiation of consent. So that's never been done, balancing the relevant harms, risks, and benefits that relate to sadomasochistic sex. And so, as it was in Jobidon, the Supreme Court will have to deal with that at some point. There are arguments in that article that you might point to. So litigate and talk to your kids or your partners even about the legal, I would say, and non-legal perils of some rough sex practices.